the is this particular proponent and makes its recommendation that if the original proponent does not match that lowest price, then for the head of the agency to award the project. But this particular situation, Your Honor, does not, as applicable to unsolicited proposal that has already been accepted on a negotiated basis, give upon the officials concerned a discretion to reject the project, the award of the project to whoever is entitled to it. When it reaches that stage, there is no option on the part of the government officials concerned but to award the project either to the original proponent or to the tenderer of the lowest price offer.
Can you cite any jurisprudence or any provision of the Constitution that will support your stand? The stand that you have just mentioned? Is there any jurisprudence? Are you aware of any jurisprudence or any specific provision of law or the Constitution
unfortunately,
which will support your stand?
With respect to the Constitution, Your Honor, I could not cite offhand any particular provision. The BOT law, especially Republic Act 7718 that amended the original BOT law, is really a relatively novel provision of law that has had very scant jurisprudence on especially the issues that are being raised here now. But I will be able to submit, Your Honor, the authorities that you're asking for.
One last point, no, Attorney. The court in Agan Jr. versus Piatco, it noted that the PBAC formally informed AEDC that it has accepted the price proposal submitted by Pair Cargo and gave AEDC 30 working days or until November 28, 1996, within which to match the said bid. Otherwise, the project would be awarded to Pair Cargo. AEDC, however, failed to match the proposal within the 30-day period. And so it informed, the DOTC Secretary informed Pair Cargo of the AEDC's failure to match the proposal. May the petitioner now rightfully invoke its alleged statutory right to be protected as an original proponent under Republic Act 7718, notwithstanding its failure to match Pair Cargo's proposal within the 30-day period?
Again, Your Honor, as I've said earlier, the right to match by petitioner AADC in this particular instance is totally irrelevant to the exercise of its right to the award of the project. Because as I've said, the right to the award of the project springs not from the fact that it had exercised its right to match, because it did not, but on the fact and on the basis of the ruling of this honorable court that Pair Cargo was not qualified to begin with to submit its price proposal. So in that respect, there was nothing to match. And there was nothing with respect to the exercise of that right to match to be made because of that reality, Your Honor, brought about by the decision of this honorable court in the Agan case.
Thank you, Attorney.
Thank you, Your Honors.
Justice Gutierrez.
Tell me, Mr. Counsel, why should the government at this stage, when it has already paid Piatco more than 3 billion, why should the government award this project to your client? What benefit will the government derive in doing so?
Well, as I've already said, Your Honor, it should award because petitioner has the right. But the government will not only receive immense benefit from awarding the contract to AADC, but it will be in the best interests of the public welfare, or the best interest of the public, Your Honor, for this contract to be awarded, because government will be relieved from an obligation that is even questionable at this point to pay Piatco either the amount of just compensation that they asks with respect to the expropriation, or the amount that it is entitled to under the principle of unjust enrichment. AADC is prepared and willing and able to comply with its obligation in this respect and pay Piatco this amount, or if not, reimburse government for whatever it has already paid to Piatco, Your Honor. So this is the benefit. But more importantly, we see here that government, in this particular instance, the respondent DOTC will be able to uphold the laws of the land, Your Honor.
Cannot understand the benefit you are saying. All right. You mean the government will be compensated, Piatco will be compensated by your client? So on the part of the government, what benefit did it derive? Or will it derive? Can you elucidate it more
Your
clearly?
Honor, once the contract is awarded, aside from what I've said about paying for the cost of construction, AADC...
You said a while ago for the public interests.
Yeah.
Please explain further.
Yeah. Well, as I've said earlier, Your Honor, the public interest angle that I have brought in is because here you will see that government will be able to make sure that what is going to be paid to Piatco will be what is right and just. And instead of government paying this, it will be AADC that will be doing this.
Why don't you think that the government will not Piatco what is fair and just?
Government cannot do that, Your Honor, because if the payment will be done either to expropriation or under the principle of quantum meruit, a BOT project that is premised under or originating from an unsolicited proposal, government cannot pay. Government cannot disburse any amount. The law prohibits government from doing that, Your Honor.
Yes, but during the circumstances obtaining now, I cannot see any benefit to be derived by the government in the process you are saying.
Your Honor, in addition to the legal arguments that I brought forth, and also the strongly grounded equitable considerations why the contract should be awarded to AADC, Your Honor, when AADC's right to the award is recognized, there will be no injury to government. In fact, government will be relieved from paying. And then AADC, when it takes over, will be able to comply with its obligations to pay government the yearly or monthly leases that it is supposed to pay under the terms of the contract that was bidded out, including with sharings in the revenue that AADC as operator of the terminal facility will be receiving. So these are all the benefits that government will be receiving. But again, Your Honor, we must bring this argument in its proper context. The reason why AADC participated and is involved in Terminal 3 is because it was AADC that volunteered, Your Honor, to help government in solving the infrastructure problems of the country. This is the primary predicate of why AADC is involved here. And on that basis, and pursuant to the law, government made commitments to AADC for purposes of being able to really build, operate the project in accordance with the BOT law, so that government will be relieved of the problem of paying for this infrastructure that it could ill afford at this time. So that by itself, Your Honor, seen in that context, is a tremendous benefit that government will be receiving. And this is the reason why the BOT law precisely has come into being to help government coming from the private sector in the putting up of this vital infrastructure that will spur the economy of this nation, Your Honor.
Tell me honestly, Counsel, in terms of financial benefit in assisting the government by your client, how much do you think your client will earn in such a good transaction or work?
Your Honor,
how much?
I do not have any information to the effect, Your Honor, but this is what I know.
But you are doing this for profit, huge profit, isn't it, Mr. Counsel?
Your Honor, when AADC came and submitted its unsolicited proposal, it was done primarily on the basis of the invitation of the former president. And the 6 Taipans that originally composed AADC responded not for purpose of making profits in this venture, but precisely to help government in putting up this infrastructure. Profit was never a consideration, in fact, of AADC in this respect.
To the Marines Council.
But this is
All right,
what
let's
has
go to
happened, Your Honor.
another topic. Can you cite any provision in the Memorandum of Understanding you executed with the DOTC that there is an existing obligation on the part of the government to recognize your right to operate the terminal project? Can you cite that specific provision? Read it
Yes,
before
Your Honor.
us.
The Section 4A of the BOT law in relation to Rule number 10.1 of the implementing rules and regulations say that when there is no other proponent that submits a price proposal within the period of the Swiss challenge, or when there is one who submits and it is lower than that offered by the original proponent, and the original proponent matches that lower price offer, the law specifically says the original proponent shall be entitled to the award of the project. The imperative command "shall" is directed upon the responsible public officials to award the contract to the original proponent, Your Honor.
But the provision is not mandatory, Counsel. Unsolicited proposals for projects may, it's not mandatory, okay?
Yes, Your Honor. Section 4A of the BOT law says may, because while it describes also the initial process at which an original proponent may be submitted and accepted on a negotiated basis, when government is not able to reach the stages that is provided for under the rules, government may still reject. And that is precisely the reason why the word "may" is there. But if you look and read on to the other provisions, once the accepting agency goes past the points that I have mentioned earlier, particularly the in-depth negotiations that has been successfully concluded and the Swiss challenge, there is no more option on the part of government. That is why the last paragraph of Section 4A of the BOT law is very explicit on that point. When the conditions are met, government shall immediately award the project to the original proponent.
Justice Puno.
Mr. Counsel, you've been informing us of the benefits as well as the disadvantages of your offer. Now let us go to the position of each party. On the part of your client, as of this time, is there any quantifiable prejudice that has been suffered by your client?
Yes, Your Honor. Just to mention the investment and the money spent in the preparation of the original proposal, and also to comply with the commitments that AADC made with government under the MOU. As I understand it, Your Honor, AADC had spent something like 180 million pesos already, Your Honor.
Now, you also take the position that your proposal would benefit the government. And in line with this, you were saying that your client is willing to complete the facilities in this terminal that are yet uncompleted. And again, would you inform the court on the basis of your current studies, how much would be necessary to complete the facilities of this terminal and make the terminal operational? Would you know?
Yes, Your Honor, maybe on a ballpark figure basis, because AADC has never been allowed to inspect the premises or the facility for that matter. But on the basis of the reports and statements attributed to government officials concerned, it will take another 100 million to complete the project. And as I understand it, there is another outstanding obligation to the general contractor, Takinaka, and of about 80 to 100 million. So in this respect, it might take a total of about 200 million to complete the project at this point, Your Honor.
Without this proffered help on the part of your client, who would bear the cost of this completion?
If we were to uphold the BOT law, Your Honor, and on the assumption that the AADC is entitled to, then it will have to be AADC. But in this particular point, if there will be no assistance coming from AADC, then it will have to be government that will be shouldering these expenses, which will be violative of the BOT law, Your Honor.
In other words, that would be a plus factor for the government in terms of finances.
That is correct, Your Honor.
Now, you were also submitting the thesis that your client is entitled to the award of this contract. When after the Agana case, the contracts were nullified. On the other hand, there is also that legal possibility that there may be a necessity for a call to another Swiss challenge. Now, would the government suffer any prejudice if there is a call for another Swiss challenge?
To begin with, Your Honors, under the implementing rules and regulations, the Swiss challenge with respect to the award of the Terminal 3 project had expired. And at this point, I am not sure whether calling for another Swiss challenge will be legal under the circumstances. But I would be willing, Your Honor, to present this in whatever memoranda that this court will require later on.
Let's not discuss first the legal aspect. My question is, would it be for the benefit of the government if there is another call for a Swiss challenge?
I don't believe so, Your Honor. Because if there will be another Swiss challenge that will be called on the basis of the existing and prevailing circumstances that have changed dramatically, maybe the financial figures will have to be changed as well. And there might not be anyone who will be attracted to coming in and invest in this kind of a project at this point because of the controversy, in addition to the controversy that has already come about here. Just consider this, Your Honor. Piatco is asking for $565 million in the ICC case. Fraport, in Exceed, Your Honor, if I may say so, is asking for something like $425 million. And these are all claims based on a separate cause of action pending before these arbitral bodies. If there will be another Swiss challenge, we first will have to deal with what to do with Piatco, what to do with the rights of AADC. And in that particular instance, I hate to anticipate the staggering implications of having a Swiss challenge under that circumstances.
Well, of course, the legal situation is quite complicated, but nobody can say at this point whether if there is a call for another Swiss challenge, there would be no participant. All this is speculation.
Yeah. Well, Your Honor, on the assuming there will be no prejudice to government because after all, the Swiss challenge will be based upon still the original proposal of AADC, which is under the terms of the draft concession agreement that incorporated this proposal. But my problem with this possibility, Your Honor, is that it will be injurious to the vested right of AADC at that point.
Well, as I said, we are not yet talking of the legality of calling for another Swiss challenge. But again, assume that there is a call for another Swiss challenge, and there is no challenger. What will happen in that instance?
AADC will still be entitled, Your Honor, to the award of the project.
Would not the legal position of your client be stronger if there is a second call for a Swiss challenge and there is no participant? Then your legal right to be awarded this project would be much better. Don't you think so?
From a practical viewpoint, Your Honor, yes. Except that the reason why the contracts were nullified was not because the Swiss challenge was tainted, Your Honor, but it was precisely founded upon the fact that this Piatco contract, so-called, failed to comply with the requirements of the Swiss challenge itself. In fact, as pointed out by this Honorable Court, the way at which these contracts came into being were riddled with so much anomalies and irregularities. So if you were to have a Swiss challenge simply on the basis of the fact that the Piatco contracts were nullified because of graft and corruption, then I am not too comfortable with that concept, Your Honor. Although I agree, from a practical viewpoint, it might strengthen AADC's position in that respect.
You were also saying that your client is ready to pay Piatco of its expenses. And to what extent would that benefit the government?
Benefit the government, Your Honor? It will benefit the government to the extent that of what government will have to pay, if it will have to pay it, Your Honor. In other words, as held by this Honorable Court in Agan, the holding specifically said that if government wants to take over the facility because it's already there and it's still useful, it can be used, then it must compensate Piatco justly. Now, to the extent of how much compensation that Piatco will be entitled pursuant to that ruling, Your Honor, will be the extent at which the government will be benefited, because that is what AADC will be paying, Your Honor.
So in other words, your client would be stepping into the shoes of the government.
That is
in
correct.
The matter of paying the obligation, whatever it is, to Piatco.
That is correct, Your Honor.
And to that extent, benefits would accrue to the government.
That is correct, Your Honor.
The more knotty problem is how much would you be paying Piatco in light of our decisions in Agan and the subsequent decision in Gingoyon. Now, do you think that the matter of compensation, the formula, and the other problems can be resolved by this court without the participation of Piatco? Will you not run into due process problems?
On the basis of the ruling of this Honorable Court in the two cases, Your Honor, personally I feel that the participation of Piatco will not be necessary. Especially so, as I understand it, Piatco has never really officially participated in these proceedings to begin with. They have even refused to participate in the Gingoyon case. They have refused to participate in the Agan case. And they have only submitted themselves to the jurisdiction of the arbitral court in Singapore. So in this particular instance, I personally feel, Your Honor, that there is no need to include Piatco in the exercise.
There is a lot of difference between what you are willing to pay Piatco and what Piatco is claiming.
That is correct, Your Honor.
In other words, the amount would radically alter the shape of the remedy of Piatco, as well as the amount that it will receive. Given those circumstances, don't you think Piatco should be heard on this issue?
The only reason why I feel, Your Honor, that Piatco should be heard is that because of its claim in the ICC arbitral body for 565 million, which is really what it claims in the form of just compensation resulting from eminent domain. Now, if Piatco will not be involved in these proceedings, in this exercise of determining what is really the amount that must be justly paid Piatco, then we might come out with an amount that will be based, let's say, on expropriation, just compensation, where there are international norms or standards that must be complied with, so that in this particular instance, let's say, government and those responsible in the determining of just compensation here in this jurisdiction will say come up with $350 million US, and that does not conform with the norms, the international norms, then we will have a problem situation with respect to Piatco in this respect. So it will always be a good idea to include Piatco. But as pointed out in the separate concurring opinion of the Honorable Chief Justice in the Agan case, the basis at which Piatco should be paid, and I feel this is what should be pursued, will be on quantum merit, on the real reasonable value of the facility, and not on the basis of just compensation under the eminent domain powers of government, Your Honor.
And what court do you suggest should untangle all these legal and factual problems?
If this
The Gingoyon Court?
I believe, Your Honor, because this case has already been consolidated together with the issues that were raised in Gingoyon, more particularly on the issue of expropriation. These are consolidated with the Mandamus case that we have brought up. This honorable court can make be part of that process and be involved in the determination of that amount, Your Honor, of compensation.
But if your prayer is granted, would that not, in effect, nullify the expropriation proceedings in the Gingoyon Court?
It will, in fact, nullify or stop the expropriation proceedings. However, it will not, to my mind, Your Honor, counter the decision of this honorable court in Gingoyon, because as I said earlier, the issue in the Gingoyon case was on whether or not government should pay just compensation when it opted to take over the property by way of expropriation. But it did not pass on the issue of the propriety or legality of the expropriation, Your Honor. That has not been an issue directly addressed before this honorable court.
Now, let me slide to another topic. The effect of the case that was filed in the Pasig Court.
Yes, Your Honor.
Who were the parties in that case?
The parties were government and DOTC and AADC, Your Honor.
And do I take it that the case was terminated because of a joint motion to dismiss filed by the parties?
That is correct, Your Honor.
At what particular stage of the case was the joint motion to dismiss filed?
Soon after it was filed, Your Honor, when this was filed sometime in But soon after it was filed, Your Honor, the former President of the Philippines called on the Taipans, asking them to dismiss the case, Your Honor. And it never reached the trial stage. It never reached any, it did not even reach the submission of pleadings, Your Honor, as I recall. It only reached the stage at which the complaint was filed.
This is to me, a very vital matter. The stage of the proceedings when the joint motion was filed. So, it was filed, of course, after the complaint. Was there already an answer filed by the respondents?
To my recollection, Your Honor, there has been no answer even. It only reached that stage of filing. And there was no answer that was filed to my recollection. If you will give me a few moments, Your Honor, I'll be able to verify that. Or as we would be discussing, my associates will be able to provide us the information, Your Honor.
And anyway, we can proceed with the other questions. Did you see the content of the joint motion to dismiss?
Yes, Your Honor.
And
We have in fact a
essentially, what does it say?
It said there that it's a really almost a one-liner provision. It says there, without the parties conceding to the respective positions that they have taken on the case, they hereby agree to dismiss the case. It was simply a dismissal of the case, not on the merits as intended by the parties, just to appease the President who wanted the case dismissed.
So let me be very clear about that. Number one, when the joint motion to dismiss was filed, the respondents have not filed their answers. In other words, the issues have not been joined.
No, Your Honor, it has not been joined. To my recollection, Your Honor.
And number two, reading the joint motion to dismiss, the parties did not discuss their respective rights and obligations vis-a-vis each other.
That is correct, Your Honor. They did not discuss. If I may read here the joint motion to dismiss, Your Honor.
Yes.
It is merely a two-page motion to dismiss. Would you allow me to read the whole motion, Your Honor? Joint motion to dismiss, the parties being Asia's Emerging Dragon and the Secretary of the Department of Transportation and Communications, Your Honor. Philippine International Terminals Company, Inc., PIATCO, and the respondents have submitted to petitioner through the Office of the Executive Secretary Malacanang a copy of the concession agreement attached as Annex A, which they executed for the construction and operation of the Ninoy Aquino International Airport Passenger Terminal. Consequently, the parties have decided to amicably settle the instant case and jointly move for the dismissal thereof without any of the parties admitting to liability or conceding to the position taken by the other in the instant case. Petitioner on one hand and the respondents on the other hand hereby release and forever discharge each other from all and any liabilities, direct or indirect, criminal or civil, which arose in connection with that civil case, Your Honor. Now,
Okay.
if I may just...
Given that kind of a joint motion, and given the order of the court, and considering that the rights of the parties were never really resolved in that case, would you say that the doctrine of preclusion would bar the litigation of that case again?
No, Your Honor, I do not think. that the doctrine of preclusion would bar AADC. In fact, it has always been the position of AADC and even government, Your Honor, that this joint motion to dismiss did not preclude them from even questioning the legality of the Piatco contracts, as in fact government did in the Agan case, Your Honor.
Thank you, Mr. Counsel.
Justice Tinga. Justice Callejo first, just for clarification.
Just for clarification, Counsel. Why then did you agree to the dismissal by the court of your petition with prejudice?
Your Honor, after we submitted the joint motion to dismiss, I was not the lawyer, Your Honor. I would not be able to.
Yes, the lawyers were Carpio, Villarasa, and Cruz. Signed, Simeon Marcelo, the former ombudsman.
And Solicitor General, Your Honor.
Why did you allow him? Why did your client allow the lawyer to agree to the dismissal with prejudice?
As I understand it, Your Honor, the dismissal, the actual dismissal of the case and the order of the court came only, came, much later. And in this particular instance, the parties felt, including government, that they were not going to question that anymore because, after all, they knew that they were not going to be precluded by the terms of the joint motion to dismiss. And they thought that that statement was a mere surplusage. In this particular instance, Your Honor, I feel that both AADC and government should have questioned it. But the fact of the matter is that neither, not even one of them, AADC or government, questioned it. But the fact of the matter is also, Your Honor, government, in violation of that order of the Honorable Court dismissing the case with prejudice, precisely took the cudgels in arguing for the nullification of this contract here in Agan versus Piatco, which has become final despite these circumstances, Your Honor. So very clearly, as I understand it, the parties really were made to understand that they did not waive any of the rights and it did not preclude them from taking the actions that they did prospectively, Your Honor.
The dismissal was with prejudice. What do you mean by that? With prejudice?
I can only really say, Your Honor, that the court went out of the bounds of the agreement by the parties.
Did your client file a motion for reconsideration or clarification of the order of the court dismissing the complaint with prejudice?
As I understand it, Your Honor, under these circumstances, it must be both government and AADC that must do so, and they did not do it.
Did your client do so? Represented by the Villarasa Law Office?
I don't believe so, Your Honor.
What is noteworthy in the joint motion is that the parties settled their differences amicably. Does that matter whether the answer has been filed or not?
Your Honor, yeah, it certainly matters, but the point I want to emphasize here in response to your question is that the dismissal of the case, whether it was with prejudice or not in the Pasig court, is of total no moment with respect to the question of whether or not the Piatco contracts were illegal or null and void, because this honorable court in Agan versus Piatco precisely decided that on the merits and with finality, where AADC was not a party. And so that, to my mind, Your Honor, I guess puts to rest the argument as to whether or not there was a preclusion, because the issues that were raised there were the issue about the legality of the Piatco contracts, the award of the project to Piatco, and this honorable court decided that in the Agan case, that they were all null and void in violation of the law, the Constitution, and public policy, Your Honor.
The parties did not only settle the case amicably in that case, they went further. I will read to you. Petitioner on the one hand, and the respondents on the other, hereby release and forever discharge each other from any and all liabilities, direct or indirect, criminal or civil. Oh, that is only embracing. What does that mean? What does civil liability include?
Your Honor, I was not part of the process.
I know.
But my point here, Your Honor, is that the waiver of any civil or criminal liability was in the context of these liabilities arising from the filing of that case, Your Honor. And this my understanding of the joint motion to dismiss.
In fact, the waiver is so all-embracing, it includes everything. Civil, criminal, or whatever. Does that include the obligation of the government to award the project to you, to your client?
I don't believe so, Your Honors, because it's very clear in the terms of the joint motion to dismiss by itself that the waiver of civil and criminal liabilities are with respect to civil and criminal liabilities arising as a result of the filing of the civil case, Your Honor.
Would you know why your client did not include in this joint motion to dismiss, open quote clauses, except the matter of the award of the project to the petitioner? Would you know why your client did not insist on that phrase to be included in the joint motion to dismiss?
I would know, Your Honor, because that was never an issue, and that was never really an issue raised in the Pasig case. Although it was part of the prayer, that was not the issue. The question of whether or not AADC is entitled as a matter of a vested legal right is an entirely separate issue. As we can see now, it is really a different threshold, Your Honor, a legal threshold that has not been discussed or adjudicated in the Pasig court case, not even in the Agan case, where the very same issues that were litigated in the Pasig case were addressed in the Agan case. The vested legal right, as we are presenting it now, Your Honor, has not been an issue in the Agan case. What we're saying here is that this vested legal right is brought for the first time as a result of the Agan case, Your Honor.
In fact, since 1999, up to now, your client never impugned the order of the court dismissing the complaint with prejudice.
There was no longer any need for that, Your Honor, because the Agan court already nullified the contracts, Your Honor.
Not this order of the court, of the RTC. In Agan, the court nullified the Piatco contracts.
Yes,
but
Your
the
Honor.
court, yes, this case was, this order of the court was never raised in Agan.
No, Your Honor, it was raised. As I pointed out, there were three issues that were raised in the Pasig case: the validity or the nullity of the proceedings in PBAC, and this related to PBAC's declaring Pair Cargo qualified when in fact it was not a qualified bidder. It did not.
I'm referring to the Agan case. This order of the RTC was never raised. It is not the subject matter of the Agan case. This order of the trial court remains unchallenged up to now.
Although in the narration of the factual circumstances, as I recall, in the Agan case by this honorable court, that was mentioned. But there was nothing said about this honorable court in that regard.
For res judicata to apply, is it necessary that the answer of the defendant be first filed before the parties can settle the case amicably and dismiss the case with prejudice? For res judicata to apply, or preclusion of issue to apply, is it necessary that the defendant must first file an answer to the complaint before the parties can settle the case amicably and bar the parties from litigating the same case?
It is necessary, Your Honor, if the dismissal